Order, order. The sitting is now resumed, and I shall call Stephen Mosley.
Thank you, Mrs. May. This debate today is on behalf of my constituent, Mrs. Anne Williams, to help seek the truth about what happened to her 15-year-old son, Kevin, at the 1989 Hillsborough disaster. All that Mrs. Williams asks for is a truth, and I hope that that message is made loud and clear to the Attorney-General over the next 90 minutes. I would like to begin by thanking my right honourable friend, the Attorney-General, for his consideration of this issue. I understand that he has recently written to Mrs. Williams to say that upon application for a new inquest, he will consider all of the evidence put before him and not restrict an application simply to new, unheard evidence. This is extremely welcome news, for which I and Mrs. Williams, who is watching this debate from the public gallery today, are extremely grateful. And of course, I would like to thank the 118,000 people who signed Mrs. Williams's e-petition calling upon my right honourable friend, the Attorney-General, to order a fresh inquest into Kevin's death. I know that Mrs. Williams would like to thank everyone who has made this debate possible. Whilst the focus of today's debate is tightly drawn around the circumstances surrounding Kevin's death at Hillsborough, and my remarks in opening the debate are similarly narrow in focus, it is important to recognise that today's debate encompasses all of those who so tragically lost their lives at the Hillsborough disaster. Both directly and indirectly, the evidence I intend to put forward relating to Kevin's death is significant in relation to all whose lives were irreversibly changed that day. I would like to make it very clear from the outset that contrary to the conclusions of the initial inquest into Kevin's death, Kevin was alive long after 3:15 p.m. on Saturday, the 15th of April 1989, and he did not die of traumatic asphyxia. The evidence is unequivocal. The testimonies are unmistakable. The original inquest into Kevin's death was wrong. All members who are present here today will be familiar with the tragic events at Hillsborough on the 15th of April 1989, and it is not my intention to recall in great detail the many accounts of what happened that day, and nor do I intend to talk about the many failings that led up to the disaster. This debate is not about pointing the finger of blame. This debate is about the truth of what happened to a 15-year-old boy. Kevin arrived at Hillsborough Football Stadium early on the 15th of April, entering the ground at around 1:30. Spotting some friends in Pen 3, he and his friend Andrew left Pen 4 at about 1:45. As the pens became more congested, Kevin, like many others, was forced to the ground. Kick-off came, and shortly after, the game was abandoned. According to the coroner, Dr. Stephen Popper, and consequently the inquest into his death, Kevin was already dead at or before 3:15 p.m. Yet at 3:28, video evidence shows Kevin being lifted out of Pen 3 and then being resuscitated on the pitch by PC Michael Craighill. PC Craighill then helped to carry Kevin across the pitch on a makeshift stretcher, along with off-duty fireman Mr. Tony O'Keefe and other Liverpool fans, including Mr. Stevie Hart, and both Mr. O'Keefe and Mr. Hart are here with Mrs. Williams today. The off-duty fire officer, Mr. Tony O'Keefe, is on record as saying that Kevin was still alive at 3:31 when he was being carried across the pitch. Mr. O'Keefe has said, and I quote, "In my opinion, he was still alive. Taking this kid and many others across that pitch, you see signs of life in someone and think, I'm going to get him to the right end of the ground and give him to someone else. I didn't have any doubt that he would be dealt with when we put him down. We carried him on a piece of hoarding to the other end of the ground, and I looked down, saw people taking over, and I thought, yeah, he's going to be okay." At 3:37, Kevin was being resuscitated by off-duty police officer PC Derek Bruder, aided by Liverpool fan Johnny Prescott and a member of St John's Ambulance, and they found a pulse in Kevin. PC Bruder had seen Kevin moving his head and being sick, so he went over to help. He saw an ambulance enter the ground and tried to stop it so that Kevin could receive medical attention. The ambulance, however, did not stop. PC Bruder provided an official statement shortly after the disaster, along with a second statement 4 months later, where he identified himself on photographs taken at Hillsborough. He was later visited at his home on the 3rd of May 1990 by Detective Inspector Sawyers of the West Midlands Police to take a further statement to clarify certain medical issues that had been made in his first statements. During that visit, Detective Inspector Sawyers rang the coroner's office and handed the phone to PC Bruder. On the phone was a pathologist, Dr. Slater, who explained that during the throes of death, a body builds up gases that can cause the body to wriggle slightly. So whilst PC Bruder was led to understand that the purpose of the visit was to clarify certain medical issues, what transpired was that the pathologist responsible for Kevin's autopsy was in fact dictating to PC Bruder what he had seen. The conversation at PC Bruder's home continued, with Detective Inspector Sawyers explaining how all of the video footage of the tragedy had been studied by the inquiry team and that the ambulance that PC Bruder made reference to in his first statement could not have been in the ground at that time, as there was no evidence to support this. Detective Inspector Sawyers then went on to question whether PC Bruder could have been mistaken about the ambulance. PC Bruder responded to these statements at the Smith scrutiny, stating that, and I quote again, "This really annoyed me, and I told him I was not mistaken, nor did I imagine the ambulance, and I insisted that he made reference to it in the statement. I told the inspector that I would be available to give evidence at the inquest, should I be required. I expected to give evidence at the inquest in order to clarify my position on the obvious grey areas that emerged. To my surprise, I was never called to give evidence in the case of Kevin Williams." These words were the sworn testimony of a registered police constable, yet they have been categorically dismissed. Following on from the visit, Detective Inspector Sawyers said at Kevin's inquest that PC Bruder was mistaken about the ambulance, that it must have been the ambulance that is on record as exiting the ground at 3:20 p.m. that PC Bruder saw, and that PC Bruder was also mistaken about finding a pulse on Kevin and also mistaken about him being sick. The coroner concluded that if PC Bruder was mistaken about the ambulance, then he must also have been mistaken about Kevin's condition. However, contrary to Detective Inspector Sawyer's comments, video and photographic evidence has subsequently emerged, along with a statement from Mr. Tony Edwards, the assistant driver of the ambulance, that confirmed PC Bruder's testimony that an ambulance did pass by them at this point at 3:37 p.m. Whilst there are serious concerns about PC Bruder being persuaded on the phone of what indeed he did say by the pathologist Dr. Slater, the underlying fact is that PC Bruder was not mistaken about the ambulance, and there was therefore no legitimate reason for his testimony to have been dismissed. At 3:40 p.m, following PC Bruder's intervention, Special WPC Deborah Martin found Kevin's pulse and helped take him into the gym. Miss Martin was told to stay with Kevin and carry out resuscitation, and this she did. After conducting heart massage and resuscitation, Kevin's ribs began to move and he stirred from unconsciousness. Thinking that she had revived Kevin, Miss Martin picked him up in her arms. Kevin opened his eyes and spoke the word, "Mum," before he slumped back and died at just before 4 p.m. This again is a sworn statement of a registered special WPC, yet the events that I will now describe are quite unbelievable. Miss Martin's original statement, made within weeks of the disaster, described the events that I have just described to you. However, a few months later, Miss Martin was visited at her home by DC Appleton of the West Midlands Police. The purpose of the visit was to seek Miss Martin's signature on a second contradictory statement. Considerable pressure was put on Miss Martin to ratify the amended statement. In the end, she succumbed to the pressure and signed the second statement without reading it. In the second statement, anything that referred to signs of life in Kevin was gone. No reference to a pulse, no reference to him saying "Mum." In total, Miss Martin was visited on 4 separate occasions by senior police officers whose aim was to convince her that her original statement was mistaken and that Kevin was not alive when she treated him. Miss Martin has stated on numerous occasions that she stands by what was in her first statement and that she was bullied by senior police officers to sign the second statement, which was wholly inaccurate. So, that is what happened to Kevin at Hillsborough. At 3:28, Kevin was pulled from pen 3 and resuscitated by a police constable. At 3:31, Kevin was carried across the pitch by, amongst others, an off-duty fire officer who swears that Kevin was still alive. At 3:37, Kevin was resuscitated by an off-duty police officer who testifies that Kevin was still alive. His statement was dismissed due to the lack of evidence relating to the whereabouts of an ambulance that has subsequently been proven to be accurate. And finally, at a few minutes before 4 p.m, a special WPC found Kevin's pulse, picked him up in her arms, and watched and listened as he opened his eyes and spoke the word Mum. Those are the facts of the day, plain and simple. Kevin was alive well after 3:15 p.m. on the 15th of April 1989. As a result of the coroner, Dr. Stephen Popper's ruling that all of the victims were either dead or brain dead by 3:15, the inquest into Kevin's death was dealt with as such. And whilst I've already dealt with key parts of the evidence that show that Kevin was unquestionably alive after 3:15, my attention is now turned to the cause of Kevin's death, an issue of equal contention to the timing of his death. At the inquest, Dr. Slater, the pathologist who conducted Kevin's autopsy, concluded that Kevin had died of traumatic asphyxia. Mrs. Williams said to me recently that although the 3:15 cut-off point was an issue that has caused great anger and distress to her and many other families who seek justice for their loved ones, the main reason that she wants a fresh inquest is because Kevin did not die of traumatic asphyxia. Since the inquest, Mrs. Williams has obtained several expert evaluations of Kevin's autopsy report, and each, without exception, has disagreed with Dr. Slater's findings. The first evaluation was courtesy of Dr. James Burns, a forensic scientist at Liverpool Royal Hospital. Dr. Burns spent considerable time with Mrs. Williams, re-evaluating the autopsy report with the evidence obtained from PC Bruder and Special WPC Martin. Dr. Burns concluded that the fractures that Kevin had suffered in the neck would have caused swelling around the windpipe. This swelling would have resulted in the gradual closing of his airway, which would have taken at least 3/4 of an hour to happen. Dr. Burns produced a report from Mrs. Williams that contradicted much of what Dr. Slater had reported. Of further interest was his letter to Mrs. Williams in relation to the evidence of WPC Deborah Martin, of which he writes, "It strikes me that Special WPC Martin has been the victim of unjustifiable adverse criticism amounting almost to ridicule. I am amazed that the evidence of Miss Martin, a dental nurse by training and a special police constable of 5 years standing, is treated with such incredulity amounting almost to hostility. I see no reason to doubt the evidence of Miss Martin when she states that she picked Kevin up in her arms. Kevin opened his eyes, moved his mouth and said, 'Mum.'" The second noteworthy evaluation was that conducted by the late Dr. Ian West, who was a former consultant forensic pathologist at London Guy's Hospital. Upon assessment of Kevin's autopsy photographs, Dr. West stated, and I quote, "They do not indicate the classic signs of traumatic asphyxia." So like Dr. Burns, Dr. West fundamentally disagreed with the official autopsy report, believing that Kevin's injuries would not have led to unconsciousness within a few seconds, and that had medically trained professionals been present, an emergency tracheotomy or cricothyroidectomy would have relieved Kevin from suffering the fatal asphyxia which led to his death. For those of you who may not be aware, traumatic asphyxia usually results from an individual being crushed or pinned under a large weight or force. The cause of a death resulting from traumatic asphyxia is not just related to the impairment of respiration, but importantly, it is also in relation to the physical interference with the return of blood from the upper part of the body to the heart. This results in the swelling and hemorrhaging of the upper part of the body, most notably in the face. Dr. West did not believe that Kevin's body displayed such symptoms concluding in his report, and I quote, "This mechanism of death by traumatic asphyxia leads to quite unmistakable pathological findings which differ from those seen in Kevin Williams's body." Dr. West explained to Mrs. Williams that had Kevin died of traumatic asphyxia and had Kevin looked the way that Dr. Slater described at the inquest, Mrs. Williams would not have even been able to recognise Kevin, and this she was able to do. I should stress at this point that Dr. West was an extremely distinguished and respected pathologist. His cases included the shooting of WPC Yvonne Fletcher, the Brighton bombing of the Conservative Party conference, the second autopsy on Robert Maxwell, and the death of Joy Gardner, the deportee who died in a police struggle. Very simply, Dr. West concluded that Kevin did not have any injuries to his chest that would have been a necessity had he died from traumatic asphyxia. The only injuries that Kevin sustained were to his neck. In 2006, Mrs. Williams sought the expertise of Dr. Nathaniel Carey, a similarly distinguished pathologist and successor to Dr. West as consultant forensic pathologist at London Guy's Hospital. Dr. Carey concurred with Dr. West's examination, concluding that the simple administration of oxygen through the insertion of a rubber tube down the windpipe would have saved Kevin. Had medical personnel been present, this would have been a routine procedure to undertake. Mrs. Williams has had 3 previous requests for a new inquest into her son's death refused by the Attorney General's office, and has been refused an inquest by the European Court of Human Rights due to timing technicalities. In light of the compelling evidence that exists, it is simply remarkable that her requests have been refused. Why is it that what clearly did happen after 3:15 that day has not been fully investigated? Why were 2 police officers pressured into changing their witness statements? Why has the opinion of 3 expert pathologists been collectively ignored? And why has Mrs. Williams never previously been granted a fresh inquest into Kevin's death when the evidence is so compelling? Mrs. Main, an inquest into a death is a fact-finding inquiry to establish reliable answers to 4 important factual questions. The first of these relates to the identity of the deceased, the second to the place of his death, the third to the time of death, and the fourth question relates to how the deceased came by their death, and they are the statutory requirements. Yet the inquest into Kevin's death has quite clearly failed to factually and reliably answer 2 of those 4 statutory questions. I hope that I've made this clear to my right honourable friend. Kevin was not dead by 3:15 on Saturday the 15th of April, and he did not die of traumatic asphyxia. I would like at this point, Mrs. Main, to add that it has been suggested that one key consideration for not previously granting Mrs. Williams a fresh inquest is because of the wider interests of all concerned. Notably, that witnesses would be required to cast their minds back to events that many have tried to put behind them. I can therefore confirm to my right honourable friend that of those individual witnesses mentioned in my remarks, Miss Deborah Martin, Mr. Derek Bruder, Mr. Johnny Prescott, Mr. Stevie Hart and Mr. Tony O'Keefe have all said very, very recently that they would be happy to give evidence should a new inquest be granted. I felt it was appropriate that I put that firmly on the record. As members of Parliament, it is our duty to represent our constituents and to fight for what is fair, just and true. I stand here today because Mrs. Williams has not been treated fairly. Justice, thus far, has not been served. And the truth that Mrs. Williams has campaigned so tirelessly to discover has yet to be officially recorded. Following the publication of documents by the Hillsborough Independent Panel this summer, Mrs. Williams will once again be submitting to the Attorney General a request for the original inquest into Kevin's death to be quashed and for a new inquest to take place. For the sake of justice, I beg the Attorney General to grant Mrs. Williams the inquest that she and Kevin so rightly deserve. Thank you.
Main. I'm going to break with convention, if I may, by actually beginning by paying tribute to Mrs Anne Williams for the determined campaign she has undertaken to seek justice for Kevin. The tireless work that she has put in and the unwavering love of a mother for her young son, tragically robbed of his life, should actually serve as a reminder, must serve as a reminder to all of us why we are in Parliament, to serve our constituents and our nation. Can I thank the Honourable Member for the City of Chester for securing this debate, and to those who have signed the petition, and indeed to all Honourable and Right Honourable Members who have supported the call over many years, too many years, for justice for those 96 who died and the 766 injured as a result of events at Hillsborough on that sad day, on 15th of April 1989. My heartfelt sympathies are with all those families affected, and can I also put on record my thanks to those who were with Kevin in his final moments, who revived him, who carried him, who cradled him. Even just reading what happened to Kevin, and so many others, profoundly moves me, but I can't begin to comprehend the pain that losing a child like Kevin must be like. A 15-year-old lad just out to watch a footy match on an afternoon. And that pain made so much worse by an inquest that was plainly wrong. I think the evidence that Anne Williams has uncovered and that we've heard today demonstrates quite clearly that Kevin was indeed alive after 3:15 p.m. and shows just how unsound the original inquests were. There has quite reasonably been a great deal of criticism of how the coroner conducted the inquest and how the 3:15 p.m. time limit has stopped important evidence being brought forward. Our outdated coroner's system needs the reforms legislated for in 2009 and more. If inquests had been properly conducted then, justice could have been achieved years ago and decades of pain could have been tempered. May I gently suggest to the Attorney-General that he speaks to his Ministry of Justice colleagues as a Chief Coroner with appropriate powers with the appeals system was one of the lessons learned from terrible events such as Hillsborough, and his government needs to rethink the implications of stripping away the Chief Coroner's powers from the Coroners and Justice Act 2009. As we heard this afternoon and on other occasions, mistakes, some genuine errors, but also incompetence and more, and worse indeed, led to the tragic events at Hillsborough. But that also mistakes and incompetence and worse incurred after the 3:15 p.m. cut-off, which has never been examined at inquests. And the cover-up that then took place was, well, to say the least, shameful. I'm pleased that the Attorney-General has said that he will look again at Kevin's case, and I look forward to hearing what he intends to do, as expectations are rightly and understandably high. I hope that the Attorney-General will set out what he can do, but as importantly, what he feels he is unable to do. If he feels bound by legal constraints, then he needs to make those clear, and then explain what, if anything, can be done to change those legal barriers. After all, that is what this House is here for, to change legislation if that's what's needed. Mrs Mayne, if I may just conclude and to give the Attorney-General plenty of time to respond. And if I may do so, again, breaking the normal conventions by turning and saying Anne and so many other families need full answers, and inquests that can properly hear testimony about what happened on that profoundly sad day are an important part of getting those answers. I do hope that before the 25th painful anniversary, we will have had a proper inquest into the tragic death of Kevin Williams, and Anne can, well, through her mother's love really, get justice for her son. Thank you.
Attorney General.
Well, Mrs Mayne, may I firstly congratulate my honourable friend, a member for the City of Chester, on securing this debate, and also to thank those other honourable members who've spoken so eloquently this afternoon about the tragedy that was Hillsborough. Today's debate has been prompted by the e-petition started by Mrs Anne Williams, mother of Kevin Williams, whose short life was ended that day at Hillsborough. There's no hierarchy of victims, Mrs Mayne. Every loss was a tragedy for someone, and I express my sympathy for all who lost loved ones on that day. Mrs Williams's petition asked that her application for a fresh inquest into the death of her son be reconsidered. I've already indicated that I will do so. It may assist if I explain what I'm being asked to do. I recognise that after hearing what others have said this afternoon, what follows may sound a little dry or legalistic. It's nonetheless necessary if what's being asked of me is to be understood. The only way in which a second inquest can be held into the death of Kevin Williams, or anyone else who died on that day, is if the High Court quashes the original inquest and orders a second inquest to be held. The court will only order a new inquest if it's satisfied that the test set out in Section 13 of the Coroners Act 1988 is met. Essentially, the test is whether a new inquest is necessary or desirable in the interests of justice. Now, that test implies a wide discretion, and it's necessarily fact-sensitive. An inquest determines who the deceased was and how, when and where they came by their death, as was so rightly explained by my honourable friend. How is not simply the medical cause of death, but may include the circumstances in which the death came about. What justice requires in any case is that there's been an effective inquiry into the death and that the conclusions reached are supported by the available evidence. If it can be shown, for example, that an inquest was flawed procedurally, or that new evidence has come to light since the inquest has been held then, if that flaw or new evidence has potentially a significant impact on the conclusions of the original inquest, then a fresh inquest may be necessary or desirable in the interests of justice. I give way to the Honourable Gentleman.
I'm grateful to the Attorney General. Would he, in the definition of what is flawed, potentially, I don't ask him to commit himself, but potentially include the existence of what many of us believe was an arbitrary 315 cut-off point?
Dominic Green.
Perhaps the best way I can put it to the Honourable Gentleman is this. Yes, I fully understand the points that have been cogently made today, raising criticisms about the 315 cut-off point. As he will appreciate, at this stage of the proceedings, I've only heard the explanations provided, but I fully understand the force that lies behind the argument that is being put forward. An application to the High Court can only be made by me or by another with my consent. My role is to consider the available evidence and determine whether there are reasonable prospects of the court ordering a new inquest. I act as a filter, as Parliament has required me to do. And I should make clear I do that role entirely independently of anyone else in government. I have given some thought about how to set about this task, and will of course consider this further in the light of the points that have been made in this debate today. Mrs. Williams has made 4 previous applications to my predecessors in office. I would add predecessors of each of the 2 major parties been in government. On each occasion, the application was refused as the Attorney General of the day did not consider there was any reasonable prospect of a court being satisfied that a fresh inquest was necessary. That there are undoubtedly difficulties. The matter's already been considered by the Divisional Court in 1992, which looked at many of the issues that had been put forward as reasons for a new inquest. That court refused to quash the original inquest and indicated it didn't consider it at all likely that the court would reach a different view had it been considering an application made under Section 13. There's also, of course, been an inquiry by Lord Justice Taylor, as he then was, and the later review by Lord Justice Stuart Smith, whose findings argued against the need for a new inquest. Now, later this year, the Hillsborough panel will release the information it's collected about the disaster and publish its report. For the first time, Mrs. Williams and the other families of the deceased will have access to all, and I stress all, relevant material, even indeed the material held by my own office in respect of the discussions that took place with previous Attorneys General. I am minded, therefore, to approach the case by awaiting the release of that material, rather than simply reviewing the material evidence that formed the basis of the applications already considered by my predecessors in office. This means that it will be necessary for me to delay reaching any conclusion until such time as the Hillsborough panel has released the collected material and there's been sufficient time for the families to be able to consider it carefully. If I were to try and reach a decision sooner, I could indeed ask to see the material the panel holds now. But I won't do that for 3 reasons. First, I don't actually want to distract the panel or do anything to delay the completion of their work, which I hope will take place shortly. Secondly, I don't want to go behind the promise given, which I think important, that the families should see the material first. Thirdly, I want to give Mrs. Williams, or indeed any other applicant, the time to consider the release material and make any representations that they may wish to make to me in respect of it. I acknowledge that taking this course will affect the timing of my decision as to whether to make an application for a second inquest, and I am, of course, prepared to consider any representations Mrs. Williams or any other interested party, or indeed their members of Parliament, may wish to make to me on timing. Yes?
Fellow.
Thank you, Mrs. May. I'm very grateful to the Attorney-General. Will he consider, in the 8 minutes that we have left of this session, consider making a statement to the House once he has had chance to look at the further evidence, look at what's come from the panel, and indeed have those discussions with Mrs. Williams and others? Will he come to the House and present his thoughts?
Dominic Grieve.
Well, I will certainly consider, if, as I have done in the past, if I come to a conclusion, I would certainly want the House to know what that conclusion is, and also the House to understand the reasonings. If it were indeed to be the case that I was going to make an application to the High Court, my reasonings would probably be very brief. If for any reason it were to be the case that I was not to be making an application to the High Court, I would want the House to understand, and indeed the public to understand, why I'd come to that conclusion. And I have to say to the honourable gentleman, the reality is that I think it would be inescapable and indeed proper that the House would require my attendance to answer questions whether I wish to make a statement or not. So for that reason, I think that I would, without anticipating where I will be in respect to this matter, I would be really rather surprised if I were not coming to make an oral statement to the House, as I think that history has shown it's a rather better way of proceeding, particularly in terms of giving adequate notice to the opposition of what I'm going to say beforehand, so that we can have a reasoned exchange of views based upon it. But I promise that I will keep the honourable gentleman, and indeed my shadow in this matter, informed of how I am proceeding in respect of it. As I was saying, it seems to me, at least, that the Hillsborough panel's work does provide an opportunity to allow for a more informed examination of the evidence. And I think that is going to be very important, because my understanding is that not only will they be sifting through material and making sure it's presented, but there will be an ability to direct attention to areas of material that might be seen to be relevant if there is to be further consideration. So for that reason, explain further my rationale behind wishing to wait for the panel report rather than just plunging into this material myself. It seems to me that it would be very sensible for me to be informed by the panel's own deliberations. Perhaps I could also make another point about my work. It's probably not greatly understood, but my office is in fact a very small one. I have a small and dedicated team of lawyers working with me, and I have one Deputy Minister, the Solicitor General. So inevitably, I'm afraid it's not the case in matters of this sort that suddenly dozens of people can be let loose on material and we can necessarily rapidly come to conclusions. That said, I'm perfectly aware that after the length of time that has elapsed, there is a real need to try to bring this matter, if I'm reconsidering it, to a conclusion, and I will be very mindful of that. But I will have to ask honourable members to bear with my office in terms of our ability to manage our workload in what I anticipate is likely to be the sifting of very substantial quantities of material, because I think there's quite a lot that's going to be in existence. I give way to the honourable gentleman.
I'm most grateful to the Attorney-General. I do understand the constraints that his office has upon it, but given the importance of this matter, not just to the House but indeed to the nation, if he finds that he is in a position where he needs more resources to undertake that work, will he come to the House and ask for that provision?
Well, I would certainly do so if I felt it necessary. We seem to manage a pretty heavy workload reasonably well. Obviously, some things come in as emergencies and some things we have to consider at greater leisure. But if I felt that I wasn't able to discharge my responsibilities more generally, I would certainly bring that to the attention of my colleagues in government. And I can assure him and reassure him of that. I have no reason to suppose that this is going to take an inordinate length of time. I want to make that quite clear. Equally, I simply wanted to stress the point, because people wouldn't necessarily understand, that mine is not a large government department with large numbers of people who can suddenly be tasked onto a particular role. Can I then make one final point? No one can fail to be moved by what happened on that fateful day in April 1989, and which still resonates so powerfully among so many people. And that, I think, was perfectly apparent to me, having listened to the debate today, and actually I wasn't able to be present, but read the debate which took place in October, which I found very illuminating in helping me to understand the concerns which have been further voiced today. I'm only too well aware of the strength of feeling this House holds about the tragic and needless deaths of so many men, women and children. Not only did that day, a day which promised only the entertainment of an FA Cup semi-final, go so badly wrong, the pain was undoubtedly compounded by unforgivable calumnies published about those who tried to help the injured and the dying. As a man and as a minister, I share those feelings. As Attorney General, in which role I'm here today, I cannot let sympathy alone sway any decision I may reach. As Attorney General in performing this function, I, as I explained earlier, act wholly independently of government and must reach my decision based on the evidence alone. What I can promise the House, and do promise, is that I'll approach this case with an open mind, and if I conclude that the evidence supports an application to the court, then I will ensure that an application is made.
Order, order. The sitting is now adjourned for 2 minutes. I shall be back.